Hello all. I think everyone has written nicely about the exam on civil procedure code. Today I am going to talk about criminal procedure code. These are only for exam revision. Okay. I have mentioned all the exam topics here and I'll discuss in detail. The code of criminal procedure is related to criminal law. The criminal justice system is essentially a maze of agencies and processes that seek to control crime, minimize crime, and impose penalties for commission of crimes. The criminal justice system consists of three main parts: legislative, which create laws; adjudication, that is courts; correction through jails, prison, probation, and parole. Components of the criminal justice system. It is a set of agencies and processes established by governments to control crime and impose penalties on those who violate laws. The major criminal justice system have five components: law enforcement, prosecution. Law enforcement, these officers take reports of for crimes that happen in their areas. Officers investigate crimes and gather and protect evidence. They may arrest offenders, give testimony during the court process, and conduct follow-up investigations if needed. Prosecution. Prosecutors are lawyers who represent the state or federal government and not the victim throughout the court process. The prosecutors review the evidence produced by law enforcement to decide whether to file charges or drop the case. Defense attorneys. They defend the accused against the government's case. They are either hired by the defendant or they are assigned by the court. Courts are run by judges whose role is to make sure the law is followed and oversee what happens in court. Judges accept or reject plea agreements, oversee trials, and sentence convicted offenders. Corrections. Correction officers supervise convicted offenders when they are in jail, in prison, or in community on probation or parole. The job is to make sure the facilities that hold the offenders are secure and safe. How the criminal justice process works. The sequence of events in the process of criminal justice are outlined here. The process may vary according to the jurisdiction, seriousness of the crime, and or accused juvenile or adult. Not every case will include all the steps, and not all cases directly follow the sequence. Entry into the system by reporting and investigation into the report, and arrest or citation if the accused is present, or if the investigating officer feels that he can arrest the victim accused. Prosecution and pre-trial, that is charges on the accused and first court appearances, bail or bond, preliminary hearing or grand jury, and arraignment. Adjudication or trial process, plea agreements and trials, post-trial sentencing or probation or parole. The next question is the rights of arrested person under law of India. Introduction. The basic rights of human being, such as the right to life and personal liberty, the right to live life with dignity, etc., are guaranteed to each individual by the Indian Constitution. Apart from this, the Universal Declaration of Human Rights set out fundamental human rights. Indian legal system follows the principle of innocent until proven guilty. The court shall think an accused person is innocent until he is proved guilty. If an accused is get arrested, he shall not be deprived of his rights, which are detailed below. Protection given to accused under Indian laws. There are 13 rights of or protections given to an accused or arrested person under various Indian laws like Constitution, Criminal Procedure Code, and Civil Procedure Code. No unnecessary restraint under Section 49 CRPC. The right to know the grounds of arrest under Section 50 and Article 22(1). Constitutional protection to arrested person, Article 22(1). Right to information of arrested person, Article Section 50A(1) under Criminal Procedure Code. Notification of substance of warrant. Right to be produced before a magistrate within 24 hours, Section 76 CRPC. and Article 22.2. Right to speedy trial, right to consult lawyer of his choice, right against self-incrimination, Article 23, right to free legal aid, right to get medically examined, right to compensation, Section 358 CRPC, right to health and safety under Section 55A CRPC. No unnecessary restraint under Section 49 CRPC. No unnecessary restraint should be applied to the arrested person than is necessary to prevent his escape. The Honorable Apex Court has framed guidelines in the below case law regarding handcuffing of arrested persons. Citizens for Democracy versus State of Assam and others. When the police arrest a person in execution of a warrant of arrest obtained from a magistrate, the person so arrested shall not be handcuffed unless the police have also obtained orders from the magistrate for the handcuffing of the person to be so arrested. Right to know the grounds of arrest. Section 50 CRPC and Article 22.1. The person arrested to be informed of grounds of arrest and of right to bail. Every police officer or other person arresting any person without a warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds of such arrest. Where a police officer arrests without a warrant any person other than a person accused of a non-bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties of his bail. Constitutional protection to arrested person under Article 22.1. The Article 22, Clause 1 of Indian Constitution mandates the information to be provided to the arrested person regarding the grounds of arrest. Right to information of arrested person under Section 50A1 CRPC. This right is protected under Section 50A1 CRPC. The police officer making the arrest shall forthwith give information regarding such arrest and place where the arrested person is being held to any of his friends, relatives, or such other persons as may be disclosed or nominated by the arrested person to give such information. Notification of substance of warrant. The police officer or other person executing the warrant of arrest shall notify the substance thereof to the arrested person and, if required, shall show him the warrant. Right to be produced before a magistrate within 24 hours. Section 76 CRPC and Article 22.2. Section 76 of CRPC and Article 22, Clause 2 of Indian Constitution provide that the accused must be produced before the magistrate within 24 hours of arrest, excluding the time of journey. Right to speedy trial. In Husainara Khatun versus Home Secretary, State Bihar, the court held that the trial is to be as disposed of as expeditiously as possible. Right to consult a lawyer of his choice. Section 41D of CRPC says the right of an arrested person to meet an advocate of his choice during the interrogation, though not throughout the interrogation. Section 303 of CRPC. Any person accused of an offence before a criminal court may have right to be defended by a pleader of his choice. Article 22.1 says no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. Right against self-incrimination under Article 20, Clause 3 says it is based on the maxim that nemo debet prodire ipsum, which means privilege against self-incrimination. Article 20, Clause 3 guarantees the right against self-incrimination, which was reflected in Nandini Satpathy versus P.L. Dani. Right to free legal aid. Section 304 CRPC, the legal aid to accused at state expenses in certain cases. In a trial before the Sessions Court, if the accused is not represented by a pleader and where it appears to the court that the accused has no sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expenses of the state. Article 39A says equal justice and free legal aid. Right to get medically examined. Under Section 54 CRPC states that if the court is duly satisfied to the extent that medical examination of the accused is necessary to defeat the justice, then the court may order medical examination of the same. Right to compensation. Under Section 358 CRPC, if an accused person is groundlessly arrested, the accused is entitled to compensation. Right to health and safety. Under 55A CRPC, it is the duty of the person having the custody of an accused to take reasonable care of the health and safety of the accused. Supreme Court guidelines for arrested persons. Case law D.K. Basu vs. State of West Bengal 1996. The Supreme Court direction on arrest of in D.K. Basu in this case, wherein the court laid down the rules for the arrest, detention, and interrogation of any person, is not being allowed widely, which gives a rise to the custodial deaths and ill treatment of the accused. Despite the Honorable Apex Court's direction on installing CCTV at all police stations, the same is not followed widely. Strict implementation of the guidelines and orders of the court has to be followed to make the state machinery more effective. Cognizable and not cognizable offense. Cognizable offense and non-cognizable offense are classifications of crime used in the legal system of India. Non-cognizable offenses include misbehavior, public annoyance, etc. All cognizable offenses are non-bailable due to their serious and heinous nature. Section 2, Clause 1 of CRPC defines non-cognizable offense. It refers to it is an offense for which a police officer has no authority to arrest without warrant. Cognizable offense. Cognizable offense means an offense in which a police officer has the authority to make an arrest without a warrant and to start an investigation with or without the permission of a court. Section 2, Clause C of CRPC 97 defines cognizable offenses. Cognizable offense means an offense in which a police officer can arrest without warrant under the first schedule of CRPC 1973 or any other law for the time being in force. Cognizable offenses are usually offenses that are serious in nature and non-bailable. Cognizable offenses are waging war or attempting to wage war against the Indian government, murder, rape, dowry death, kidnap, theft, criminal breach of trust, and natural crime. Section 154 of Code of CRPC states that under cognizable offense, a police officer has to receive FIR related to cognizable offense. Power of police officer to investigate in cognizable offences. Section 156 talks about the police officer's power to investigate cognizable cases. Any officer of a police station, without the order of the magistrate, shall investigate any cognizable matter in which the court having jurisdiction over the local area within the limits of such station shall have the power to inquire or trial under the provisions of Criminal Procedure Code. Any magistrate empowered to take cognizance under Section 190 of the Code, and then the magistrate may order investigation. If a police officer refuses to register an FIR, then the person can file an application before the magistrate and will be treated as an application under Section 156, Clause 3, or he can file a protest petition. The order of the Section 156 Clause 3 is always a pre-cognizance order, but after 2019, the Supreme Court held that an order of Section 156 Clause 3 can be passed even at the post-cognizance state. If a police officer is not investigating even after the order is passed, then the magistrate can pass another order to investigate. Coming to non-cognizable offense. Non-cognizable offense means a case in which a police officer has no authority to arrest without warrant. Non-cognizable offenses are not so much serious as cognizable offenses. In case of non-cognizable offense, a police officer does not have the authority to arrest any person without a warrant, and investigation cannot start without an order of court or magistrate. Example: attack, cheat, forgery. In this type of crimes, a criminal Complaint is lodged with the Metropolitan Magistrate, who is supposed to order the concerned police station to initiate an investigation. Section 155 of CRPC states that in a non-cognizable offence, the police officer cannot record an FIR unless he is obtained prior permission from the magistrate. In the case of non-cognizable offence, the police officer needs to obtain permission from the magistrate to initiate an investigation. Following steps should be taken in such crimes for arrest: complaint filing or FIR, investigation, charge sheet should be filed, charge sheet should be filed in court, trial, the final order of arrest if the case is done. Coming to differences between cognizable and non-cognizable offense. Cognizable offense, the police officer can arrest without warrant. Non-cognizable offense, the police officer cannot arrest without warrant. In the cognizable, the police can start an investigation without the court permission or FIR. In the non-cognizable, the police cannot start investigation without the permission of the court. In cognizable, these are cognizable offenses are heinous crimes like murder, rape, dowry deaths, etc. Non-cognizable are not serious crimes like forgery, cheating, defamation. The victim can file an FIR or make a complaint to the magistrate in cognizable offenses. The victim can make a complaint to the magistrate in non-cognizable. Can be both bailable or non-bailable offenses in cognizable. Non-cognizable offenses are bailable offenses. Case laws. Supreme Court of India versus in Lalita Kumari versus Government of UP. In this case, the court held that if the complaint reveals a cognizable offence, the police must compulsory file an FIR on filing the complaint. And in such a situation, no preliminary inquiry is acceptable. Muhammad Yusuf versus Afaq Jahan. In this case, the court held that the officer in charge of the police station has to register an FIR before investigation under Section 156(3) of CRPC, even if the magistrate does not explicitly say so. In Chinnaswamy versus Kuppuswamy, it is observed that the purpose of code is to ensure the independence and security of the subject, that it confers on him the right to come to court provided that the court considers that a wrong has been done to the public or him, and the police cause, cause irregularities. Consequences of non-compliance with the provisions relating to arrest. When we hear the word arrest, our hearts still and stop beating, our lungs stop breathing, and our bodies begin to tremble. Even today, in many parts of society, an arrest is regarded as conviction or proof of a crime. Arrest is a practical infringement of a person's right to liberty under Article 19 and 21 of the Indian Constitution. As a result, the power to arrest must be used with due care and prudence rather than based on authorities' whims. Regardless of whether an arrest is undertaken without or with a warrant, it is required that the police officer or any other authorized person arresting touches or confines the body of such person who is to be detained unless the person gives himself willfully, either by words or deed. Every police officer who makes an arrest is required by Section 41B of the CRPC to carry an accurate, visible, and clear identification of his name in order to assist easy identification. The police officer must create a memorandum to record the arrest, which must be signed by a family member or any other independent person who is a respectable member of society. If the arrestee's family members are not present at the time of the arrest, the arrestee must be informed of his right to inform one family member or friend about his arrest in order to successfully obtain bail or bond. In two historic and classic decisions, Joginder Singh versus State of UP and D.K. Basu versus State of West Bengal, the top court has given down extensive instructions with respect to arrest procedure. Procedure to be followed during arrest. The police must enter time and place of arrest in the police notebook as well as who is has been informed of the arrest in the police diary. During his imprisonment, the arrestee must be subjected to medical examination by trained doctors every 48 hours. During interrogation, the arrestee may be permitted to meet his lawyer. All district and state police control rooms must be notified about the arrest in order to in order for the arrestee's relatives to find him or her easily. Consequences of failure to follow procedures. The CRPC imposes strict procedural standards for carrying out an arrest. However, no provision is made for the penalties that will occur if these protocols are not allowed. No law addresses the liability of police personnel or state in the event of non-compliance with the rules or whether such an arrest is legitimate or illegal. In such a case, the court's decisions serve as a guiding light for this subject. The following are the implications of failing to satisfy the procedural requirements of an arrest in a different legal context. Impact on arrest. If the police officer brazenly disregards all of the procedures outlined in the CRPC while arresting a person, the arrest is deemed illegal. On the other hand, it is an irregular arrest if the specific provisions are not followed while the remainder of the law is followed. In any case, the arrest is invalid and the magistrate must be aware of the nature of illegality of the arrest when the arrestee is brought before him for the first time. Impact on trial. When the investigation is complete and the police officers have uncovered sufficient evidence against the accused, they charge him with specific crimes and the court decides whether the accused is guilty or innocent. A trial will not be thrown out just because the arrest provisions were not followed to the letter. Though the illegality or irregularity of the arrest will not invalidate the accused trial, it will be significant if the charge against such a person is resistance to or escape from the police lawful custody. The validity of the charge is tainted by the illegal detention. Impact on court jurisdiction. It is possible that a public servant may arrest a person in one part of the state while the charge sheet is filed in another part of the state where the police station is located while acting unlawfully in the exercise of his powers. The fact that the officer who made the arrest went beyond his authority in making the arrest has no bearing on the court's jurisdiction or try the accused. In Rishput versus State of Delhi, the court stated that failure to follow the arrest procedure is merely a procedural effect that does not go deep enough into the subject to eliminate the court jurisdiction. State liability. In practice, the state's relationship with the police department is that of an employer and the employee, or in traditional legal terms, a master servant relationship. The master shall be accountable for the wrongful conduct of the servant committed during the course of his employment according to various liability laws. Now, a police officer's arrest is an official task that he performs while wearing his official uniform. As a result, if a police officer makes an illegal arrest, the state should be held accountable. In Nagendra versus State of Arunachal Pradesh, the Supreme Court rejected the government's employees' sovereign immunity defense established in Kasturi Lal case and found that the state can be held liable for wrongful acts of the police officers. Prosecution of the offender. If a public servant with the authority to arrest knowingly exercises the authority in violation of the law and makes an illegal arrest, he can be prosecuted under Section 220 of the Indian Penal Code 1860 for the same offence, which carries maximum sentence of 7 years in prison. Aside from this specific provision, anyone, including a police officer, can be charged under Section 342 of the Penal Code for wrongful confined imprisonment. Civil action against the criminal. A tort is a civil law that is typically uncodified and developed by common law courts. False imprisonment is a tort in which a person restricts the free movement of another person and confines that person without his or her knowledge or agreement. In such circumstances, if the defendant is found guilty, he or she must pay the plaintiff monetary charges. Right to self-defense. The right to defend oneself and one's property is a general exception to the commission of an offense under the Indian Penal Code, which is of several general exceptions to offenses. This right allows anyone facing an imminent threat to his life or her life, person or property, or the life of or property of another person to use proportional force to stop or avoid the threat. If a person is arrested or detained legally, he or she has the right to defend himself against any force used in the arrest, as well as the right to flee from the public servant if the arrest is illegal. Ubi jus ibi remedium. The ubi jus ibi remedium, which means there is remedy for every injustice. If there is no remedy for a violation of rights, the law is useless. The victim might seek two types of redress if the arrest procedure is not followed. Relief from imprisonment. It is if it is determined that a person has been wrongfully detained, the High Courts or the Supreme Court can issue a writ in the nature of habeas corpus ordering the person's release. The Supreme Court issued a writ of habeas corpus in Sebastian Hungray versus Union of India and others, ordering the respondents to release two listed individuals and if they cannot show cause, may they why they cannot be presented before the court. Maintenance of wives, children, and parents. Introduction. Scope and objectives of order for maintenance of wives, children, and parents. Who can claim and get maintenance? The wife, legitimate or illegitimate minor child, legitimate or illegitimate abnormal child who has attained majority, father or mother. Essential conditions for granting maintenance. Jurisdiction of magistrates to deal with maintenance proceedings. Procedure for maintenance. Enforcement of order of maintenance. Conclusion. Coming to introduction, the word maintenance is not defined in the Code of Criminal Procedure 1973. Chapter 9 of the Code of Criminal Procedures deal with provisions for maintenance of wives, children, and parents. Maintenance in legal meaning is money that someone must pay regularly to a former wife, husband, or partner, especially when they have had children together. It is the duty of every person to maintain his wife, children, and aged parents who are not able to live on their own. Scope and objective of proceedings. The proceedings are not punishable in nature. The main objective of Chapter 9 of CRPC is not to punish a person who is not maintaining those whom he is bound to maintain. The main objective is to prevent homelessness by way of procedure to provide a speedy remedy to those who are in pain. It does not make any distinction between persons belonging to different religions or castes. It has no relation to the personal loss of parties. Order for maintenance of wives, children, parents. Section 125 of CRPC deals with order of maintenance of wives, children, and parents. In this section, it is given the name of the parties who are entitled to get maintenance, essential ingredients to claim and get maintenance, and order of the first class magistrate. In case of Muhammad Ahmad Khan versus Shah Bano Begum, the Supreme Court delivered a judgment favoring maintenance given to an aggrieved divorced Muslim woman who can claim and get maintenance. Under Section 125(1), the following person can claim and get maintenance are wife from husband, legitimate or illegitimate minor child from his father, father or mother from his son or daughter. Wife. In case of Chanmunia versus Virender Singh, Supreme Court has defined wife and it includes even those cases where a man and woman have been living together as husband and wife for a reasonably long period of time. Strict proof of marriage should not be a precondition of maintenance under Section 125 of CRPC. A wife can claim she is divorced by her husband or obtained divorce from her husband and she is not remarried and she is not able to maintain herself. A wife cannot claim wife living in adultery or refuses to live with husband without any valid reasons, living separately by mutual consent. Legitimate or illegitimate minor child, son. Minor means a person who, under the provisions of Section 3 of the Indian Majority Act 1875, is deemed not to have attained his majority, that is, above age of 18 years. Minor son, whether legitimate or illegitimate, is entitled to get maintenance under Section 125 CRPC. Daughter. If minor daughter, whether legitimate or illegitimate, is unmarried, then she is entitled to get maintenance from her father, and if she is married, then she is also entitled to get maintenance from his father, but the magistrate has to be satisfied that her husband has not essential and sufficient means for maintenance of his minor wife. In the case of Shabuddin versus State of UP, a minor daughter attaining majority during the pendency of application for maintenance was held entitled to maintenance up to the age of date of majority. Legitimate or illegitimate abnormal child who has attained majority. If any major child is abnormal, that is mentally or physically unfit, then the father of that child has to maintain him and he can claim maintenance on this ground of abnormality. Father or mother. Natural father and mother can claim maintenance. Mother includes adoptive mother. She can claim maintenance from adoptive son. Father can claim maintenance. It is a statutory obligation. This claim cannot be defeated by pleading that the father failed to fulfill his parental obligation. A childless stepmother can claim maintenance. In case of Dabade versus Dabade, PB Dabade versus BB Dabade, Bombay High Court has held that the father or mother can claim maintenance under Section 125, Class 1, Subsection D, if he or she is unable to maintain himself or herself. But it is also important that if parents claim maintenance to their children, children must have sufficient means to maintain their parents and yet neglects or refuses to maintain the father or mother. Essential conditions for granting maintenance. There are some essential conditions which should be fulfilled for claiming and granting maintenance. Sufficient means for maintenance are available. Neglect or refusal to maintain after the demand for maintenance, the person claiming maintenance must be unable to maintain himself or herself. The quantum of maintenance depends on the standard of living. Jurisdiction of magistrate to deal with maintenance proceedings. According to Section 125(1)(d), if any person neglects or refuses to maintain his wife, children, or parents, then a magistrate of first class can order such person to make a monthly allowance for the maintenance of his wife, children, or parents. As such monthly rate, as such magistrate thinks fit, and to pay the same to such person as the direction of the magistrate. Enforcement of order of maintenance. Section 125 deals with enforcement of order of maintenance. According to this section, the following are the conditions for enforcement of the order of maintenance. Copy of the order under Section 125 is given to the person free of cost in whose favor it is made. In case the order is in favor of children, then the copy of the order will be given to the guardian of children. If any magistrate has made an order under Section 125, then any magistrate of India can enforce this order where that person lives who have to give maintenance. The magistrate has to satisfy two conditions before enforcement of order: identity of parties and proof of non-payment of allowances. Thus concluding, Chapter 9 of the Code of Criminal Procedure is essential for the protection of the rights of the divorced wife, children, and aged parents. It is made to protect them from unusual livelihood. Maintenance is the duty of everyone who has sufficient means for the same. Coming to seizure, mostly comes as case law. Chapter 7, containing sections 91 to 100 of the Code of CRPC 1973, deals with provisions relating to summons to produce documents or the things, search warrant provisions, and other laws related to search and seizure. A summon is a command from a court to an individual to appear at a given time and place before him. In both civil and criminal cases, a summon can be issued. A warrant is a legal document that is issued by a judge or magistrate authorizing a police officer to make an arrest, search, seize property, or take action relating to administration of the justice system. The word search refers to the operation of government machinery that involves checking through or carefully inspecting a location, area, person, object, etc. to detect something hidden or to reveal the pieces of evidence of crime. The police can look out for an individual or a car or premises, but only after taking necessary or legitimate lawful approval. Seizure is a vigorous action that unexpectedly takes over, captures, removes, or overwhelms an entity of or an individual. The act of taking items from the crime scene that can serve as evidence, the act of overwhelming, removing, or grabbing a person or object. The search and seizure is a procedure by which the police and other authority, when suspect a crime has been committed, start the process of searching for the person's property and seize the relevant things in the connection to the crime. The main reason for which search and seizure have a provision in the law is to get evidence for the case. The search here includes a search of a person, place, or any belonging of a person. These search and seizure can be done by the police authority, investigation authority, or any other authority who has the power to do the act. Search and seizure has been known term in civil and criminal proceedings. Constitutional validity of search. In many instances, search and seizure laws are stated constitutionally invalid, which violates the fundamental right under Article 19(1)(f) and Article 23. In case of Maneka Gandhi versus Union of India, the Supreme Court interpreted the phrase procedure established by law in Article 21. This means that not only humans but the law should also be fair and reasonable without being arbitrary. In Puran Mal's case, it was stated that the search and seizure laws in Section 132 about the Income Tax Act 1961 and Rule 112 was a violative of Article 19(1)(f) or Article 19(1)(g) of the Constitution. The court held that the laws are reasonable and are not violative of any fundamental right. Right to privacy. The search and seizure laws are included in many acts and provisions like the MPDS Act, Customs Act, Passport Act, Income Tax Act, etc. In case of Income Tax Office versus Seth Bros, it was stated that Section 132 of Income Tax Act, which provides for search and seizure, does not prescribe any authority over the revenue officers. Mere power of the authority cannot take away the right and privacy of a taxpayer. The power is given to the authority concerning the law. Rules to be followed in search and seizure cases. The Union Minister gave the rules for search and seizure laws under specific acts like Income Tax Acts, Customs Acts, etc. Some rules provided are competent authority. There should be a formal order that should be issued before the issue of such order. The person who is given authority to search and seizure should not give reason for after the exercise of such power. The objective of search. The objective of search is always necessary, and with no objective, it violates the privacy of the person where the search is made. Search party. The search party should be held by an officer with the rank of assistant collector or any equivalent post. The team led by the assistant collector should consist of 2 witnesses of the locality and technical people. Examination and report to the authority. The authority must examine the product or the person which they have searched or found. In case of income tax, the true owner of the product has to take an oath. The statements taken from the person by the authorities make them liable under the law. After the examination is complete, they have to send a report to the senior authority. After this, the arrest and the departmental proceedings will take place and the person will be prosecuted under the various acts for the offense. Laws related to search and seizure. The laws about search and seizure are the same. Search and seizure are the main part of investigation of case. Thus, the Criminal Procedure Code gives the important provision for search and seizure. The police can do search and seizure by using a warrant under CRPC. 93, when a search warrant can be issued. Sections 94, search of a place suspected. Section 95, the power to declare publication forfeited and issue of search warrant. Section 97 says search for persons wrongfully confined. Section 100 is the gives basic provisions related to search and seizure. Section 102 gives the power of the police officers to seize. And without warrant under section 103, if without warrant, magistrate may direct to search for his presence. Section 165 gives guidelines regarding the search by a police officer. Section 166, when a police officer is in charge of a police station, he may require another person to issue a search warrant. Police and other authorities that are entitled to maintain law and order are the main people for a vast nation like India, which has a large number of crime rates daily when the majority of them unsolved, where the majority of them are unsolved. In this process, search and seizure constitute a vital component of the whole investigation proceedings. Many feel that search and seizure proceedings by the authority are violative of their fundamental right to privacy of the citizens of our nation. Even the courts also, in some cases, felt that it is violative, but in many cases found this way to be an effective part of investigation. The search and seizure do not have any particular act, rather are present in many acts and provisions in their dimensions. Coming to fair trial. What is fair trial? The main aim of the criminal justice system of India is to ensure fair and impartial trial of each and every accused who has been put behind bars in the Indian territory. Lex ori omnes alloquitur, which means that everyone is equal before the eyes of the law, which is an important principle which forms the basis of judicial proceedings across the world. So, Article 14 of the Indian Constitution exclusively deals with the right to equality. Conducting fair trials is an important aspect of the law which ensures equality. Define fair trial. The right to a fair trial is guaranteed under Article 7, which includes various rights like right to appeal to the competent jurisdiction, right to defense, right to be tried, right to be presumed innocent until proven otherwise. There is no proper definition of the term trial in the Code of Criminal Procedure 1973. The trials are an examination of offence by the judicial bodies which have jurisdiction over it. A fair trial is an open trial by an impartial judge in which all parties are treated equally. A fair trial includes fair and proper opportunities allowed by law to prove innocence. In Center for Public Interest Litigation versus Union of India, case, the court observed it is often said that justice should not only be done, but it should appear to have been done. Indian Constitution of on fair trial. Article 21 of Indian Constitution, no person shall be deprived of his life and personal liberty except according to procedure established by law. The right to defend oneself and for the purpose of to deduce evidence is recognized by the Parliament in terms of subsection 2 of section 243 of the Code. Principles of fair trial. The following are the principles of fair trial are adversary trial system, presumption of innocence, independent, impartial and competent judge, knowledge of accusation, right to open trial, right to free legal aid, trial in presence of accused, evidence to be taken in presence of accused, protection against illegal arrest, right to bail, prohibition on double jeopardy, right against self-incrimination, right to appeal. Presumption of innocence. Under this principle, each and every accused is presumed to be innocent unless proved guilty of the crime beyond reasonable doubts. The burden of proving the accused guilty is on the prosecution. The presumption of innocence is present at the beginning of all the criminal trials in an adversary system. This principle is based on the underlying fact that there must not be a wrongful conviction of an innocent person, as this will decrease and shake the confidence of the people in the Indian judicial system. Case laws. In the landmark case of Jahira Habibullah Sheikh and others versus State of Gujarat, the Supreme Court has defined fair trial as a trial before an impartial judge, a fair prosecutor, and atmosphere of judicial calm. The Supreme Court said that a denial of a fair trial is as much injustice to the accused as is to the victim and the society. The State of UP versus Naresh and others, Chandrappa and others versus Karnataka 2007, Supreme Court held that the presumption of innocence is available to the accused under fundamental principle of criminal jurisprudence that every person should be presumed to be innocent unless proved guilty by the competent court of law in a criminal trial. Magistrate regarding the confession and its validity. This is the next question. The confession is a statement made by an accused in which he admits to the commission of a offense alleged. Confession is nothing but an admission. Admissions are made in both proceedings, civil as well as criminal. If a person admits a statement regarding that offense, then that statement should be known as confession statement. It is pertinent to note that all confessions are admissions, but not all admissions are confessions. Kinds of confessions: judicial confession and extrajudicial confession. Judicial confession: when a person can give confession before the magistrate, then that confession is called judicial confession. And extrajudicial confession: when a person can give confession in the absence of a judicial magistrate or outside the judicial court, then it is considered as an extrajudicial confession. The court can consider both judicial and extrajudicial confession, but both confessions have different evidentiary value or probative value, so that establishes any fact. Confession and Magistrate, Section 164 CRPC 1973. Any metropolitan magistrate or judicial magistrate not even having jurisdiction in the case has the authority to record a confession or statement made to him by a person in the course of an investigation or after it, but invariably prior to the inquiry or the trial. Even a private party or victim's pleader can request the magistrate to record the statement of a person, but the magistrate has enough discretion to refuse to do so. But a magistrate has enough discretion to refuse to record a statement if the police report or other records already can disclose the fact which the person intends to record at trial. Procedure of recording. Section 164(1) says that this puts forth that judicial magistrate or any metropolitan magistrate, whether or not he has jurisdiction, can record any confession or any statement made to him during the process of investigation or under any other law for the time being in force or at any time before or afterwards before the commencement of the inquiry or the trial. 164(2) section says that before recording the confession, the magistrate shall explain to the person giving the confession that he is not bound to confess, and if he does confess, then it may be used as an evidence against him. Then confession should be voluntary. Section 164, Class 4 says that a confession shall be recorded in the manner that has been laid down under Section 281 for recording the examination of an accused person and shall be signed by the person making the confession. This is followed by magistrate making a memorandum at the foot of such record. Section 164(5) Class 5 says any statement except for a confession made under subsection 1 shall be recorded in a manner as per the specified one set for the recording of evidence as is in the opinion of the magistrate best fitted to the circumstances of the case. The magistrate shall have the power to administer the oath to the person whose statement is recorded. Section 164, Class 6 states that the magistrate regarding the confession or statement shall forward it to the magistrate by whom the case is to be tried. Coming to the next, non-compliance of the Section 164 or 281 of the CRPC. If the provisions of Section 164 or Section 281 of CRPC are not followed, then the evidence can be taken for such non-compliance. Such a statement may be admitted if the magistrate is satisfied that the non-compliance has not injured the accused in his defense on the merits that the statement was duly made. Case law in GP Anna Rao versus and others versus State of Andhra Pradesh, it was held that the statement of witness recorded under Section 164 CRPC is a public document. It does not require any formal proof and there is no necessity to summon the magistrate who records it. Coming to different criminal courts in CRPC and their powers of punishment. Introduction. Indian judiciary is one of the most efficient judicial systems in the world. The judiciary derives its power from the Constitution of India. The existence of courts is required to check the misuse of the powers conferred by the legislature or the executive. The Indian judiciary is the guardian of the Constitution of India, along with being a custodian of the fundamental rights of the citizen. The Indian judiciary is well established with quite a lengthy and complex hierarchy of courts. The judicial system is in the form of a pyramid, with the apex court being at the top of the hierarchy. Criminal Codes. Section 6 to 24 of the Code of Criminal Procedure deals with the constitution of criminal courts. As a result of the separation of judiciary from executive, now there are two types of magistrate, namely judicial magistrate and executive magistrate. Judicial magistrates are under control of the High Court. Executive magistrates are under control of the state government. Functionaries under the CRPC are enforcement machinery. The functionaries which are empowered to exercise the powers and discharge duties under the code are police, prosecutors, courts, defense counsel, prison authority, and correctional services. Amongst these, the role of magistrates and courts is pivotal, while others are in a way accessories to it. Hierarchy of criminal courts. The Supreme Court of India, being the apex court of India, was established under Article 124, Part 5 and Chapter 4 of the Constitution of India. High Courts of India. The High Courts are at the second level of the hierarchy. They are governed by Article 121 of the Constitution of India and are bound by the judgment of the apex court. Lower courts of India have been classified as follows: metropolitan courts and district courts. Metropolitan courts are classified as Sessions Court, Chief Metropolitan Magistrates, First Class Metropolitan Magistrates. District courts are classified as Session Courts, First Class Judicial Magistrate, Second Class Judicial Magistrate, and Executive Magistrate. This is a hierarchy of criminal courts. From High Courts, the Session Courts of the District and Metropolitan will come. Assistant session courts are both in the case of metropolitan, it is chief metropolitan magistrate or additional metropolitan magistrate, and in the district courts, district level, chief judicial magistrate or additional chief judicial magistrate. The below rank in metropolitan are metropolitan magistrate and special metropolitan magistrate. Below rank under chief judicial magistrate are subdivisional judicial magistrate, and below them are judicial magistrate of first class and judicial magistrate of second class. Court of Session. Section 9 of the CRPC empowers the state government to establish the session court, and such court would be presided over by a judge appointed by the High Court. The additional and assistant session judges are also appointed by the High Court to exercise jurisdiction in the Court of Session. The Sessions Court ordinarily sits at such place or places as ordered by the High Court, but if in a case the Court of Sessions decides to cater to the general convenience of the parties and witnesses, then it may, with the consent of the prosecution and the accused, preside its sittings at any other place. As per Section 10 of the CRPC, the assistant sessions judges are answerable to the session judge. Court of Judicial Magistrate. Section 11 of CRPC states that in every district not being a metropolitan, the state government, after consultation with the High Court, has the power to establish courts of judicial magistrates of the first and second classes. The Chief Judicial Magistrate and Additional Judicial Magistrate, Chief Judicial Magistrate. As per Section 12 of the Code, in every district other than metropolitan areas, judicial magistrate of the first class shall be appointed as the Chief Judicial Magistrate. The High Court is also empowered to designate judicial magistrate of first class as additional Chief Judicial Magistrate, and by such designation, the magistrate shall be empowered to exercise all or any of the powers of the Chief Judicial Magistrate. Local jurisdiction of judicial magistrate. According to Section 14, the Chief Judicial Magistrate shall define the local limits of the areas within which the magistrates appointed under Section 11 and under Section 13 may exercise all or any of the powers with which they may be vested under this code. The Special Judicial Magistrate may hold its sitting at any place within the local area for which it is established. The jurisdiction in case of juveniles, which are discussed under Section 27. This section directs that a juvenile, that is a person below the age of 16, cannot be given a death penalty or punishment of imprisonment for life. Chief Judicial Magistrate or any other court specially empowered under the Children Act 1960 tries such type of cases. Juvenile in conflict. Introduction. A Latin maxim that suits best for the juvenile justice system in India is nil novi spectrum, which implies nothing is new on this earth. In the last few years, it is also observed that crimes done by children under the age of 15 to 16 have increased significantly. The general tendency or the psychology behind the commitment of crime or the causes of the crime are early life experiences, dominant masculinity, upbringing, economic havocs, lack of education, etc. Definition of child and juvenile under the Juvenile Justice Act. According to subsection 12 of section 2 of the Juvenile Act 2015, a child means a person who has not completed 18 years of the age. The Act classifies the term child into two categories: child in conflict with law and child in need of care and protection. Child who has committed an offence and he or she is under the age of 18 years on the date of commission of the offence is basically called as child in conflict with law. Child in need of care and protection means a child is defined as under section 14 of the act. Coming to juvenile. Juvenile is a person between the age group of 16 to 18 years. A young person who is being accused of crime is a juvenile offender and is tried as adult in court proceedings. The juvenile either indicates immature person or young offenders. Justice Act 2000. The act was enacted in the year 2000 with the aim and intent to provide protection for children. The mentioned uh, was amended twice, first in the year 2006 and later in the year 2011. Further, the increasing number of cases of the juvenile crimes in the last recent years and a frightful incident of Delhi gang rape case has forced the lawmakers to come up with a law. The major drawback of the act was that it contains ill-equipped legal provisions and malfunctioning juvenile system was also the major reason for preventing the juvenile crimes in India. The act was replaced soon by Juvenile Justice Care and Protection Act 2015. The juvenile justice system in India 2015 is made on the basis of three main assumptions. Young offenders should not be tried in the courts, rather, they should be corrected in all the best possible ways. They should not be punished by the courts, but they should get a chance to reform. Trial for child in conflict with law should be based on non penal treatment through the communities based upon the social control agencies. For example, observation homes and special homes. Nirbhaya case. This case involved the gang rape and murder of a paramedical student in New Delhi in December 2012. Mukesh versus State NCT of Delhi. During commission of the crime, one of the accused was 17 years old. Thus, because of the juvenile laws at that time, the rapist was not dealt with harshly in comparison with the other rapists. Others were sentenced to death. According to the report by the Juvenile Justice Board, there is no evidence showcasing him as being the most vicious offender who committed the crime. Consequently, he was released from the reformation home after 3 years. Due to the massive outcry in 2015, the laws were changed, imposing penalties on children in conflict with law. Later, the Lok Sabha passed a Juvenile Justice Care and Protection of Children Act, which states that children aged 16 to 18 could be treated and charged for heinous crimes as adults. Amendments of Juvenile Justice Act 2015. There have been many major changes in the criminal system of India due to Delhi gang rape case. The Juvenile Justice Act 2000 was repealed by the Indian government on 15th January 2016. Among the main objectives of passing the amendment was to curb the heinous crimes committed by the minors between 16 and 18 years of age, such as rape. The amendment of Juvenile Justice Act 2015 or an accused minor older than 16 should be present himself or herself to the Juvenile Justice Board. The board will then decide whether to proceed with the trial as an adult or to send the juvenile to rehabilitation. The decision is based on the physical and mental capabilities of the child. In accordance with the Juvenile Justice Act, a minor 16 to 18 years of age is considered as adult if he or she has committed any heinous crime. Minor who has committed a serious offense may be tried as an adult only if he is apprehended after the age of 21 years. Case Law 2. Sadbir Singh versus and others versus State of Haryana. The Supreme Court reiterated that for the purpose of determination whether the accused is juvenile or not, the date of birth which is recorded on the school records shall be taken into consideration as by the Juvenile Justice Board. All the best for your exams. Thank you. Please like, share, and subscribe.